to read it. And do we have someone here that represents the first application, or is it on Zoom? Okay, sir, would you like to come forward and push that center button on the mic and then state your name, please? Yeah, center button, and you might want to pull that mic around a little bit. There.
Yes, my name is Corrado Lupo. I live at 2724 Lone Birch Trail.
Okay, very good, sir.
Okay.
The secretary treasurer will read the report and then you can make comments afterwards.
Sure.
Very good. Yeah.
Good morning, everybody. So today we are going to discuss the first item on our agenda, 4.1, for the applications, which would be file B124 for the property 2724 Lone Birch Trail. So we just have a little imagery here. So the application has been submitted by Corrado and Susan Lupo, owners requesting consent in order to convey approximately 14.7 square meters of land, the adjacent property being the 2728 Lone Birch Trail. The property adjustment being proposed does not affect the existing frontage of either land parcel, as the lands to be conveyed are part of Block C of Plan 874, which abuts the water. Block C is also under the private ownership of Corrado and Susan Lupo, the applicants. A legal opinion has been submitted with this application regarding the proposed conveyance to provide further context on the requested boundary changes, and additionally to provide historical information regarding the subject lands. And then here we just see a site plan showing the proposed adjustments. So we have 2724 Lone Birch Trail, 2728 Lone Birch Trail, Block C wrapping around them. So the request is simply to adjust this boundary here so that this section is conveyed to the owners of 2728 Lone Birch Trail. So the application was circulated in accordance with the Planning Act. Both the Building and Infrastructure Departments commented no concerns with the application. Lori Bax has submitted comments outlining concerns regarding various landowner rights to access the water through Block C. And the full comments are attached as an addendum to today's agenda. I believe they were attached either Thursday or Friday of this past week. Additionally, as an addendum, Elzbieta Malarski has submitted comments and they outline concerns regarding potential for rezoning of the property as well as community access through Block C. And again, the full comments are attached as an addendum under item 4.2. In terms of policy, the subject lands are within the boundaries of the Lake Simcoe Protection Plan. They are regulated by the boundaries of the Lake Simcoe Conservation Authority. And they're within an area for growth according to a place to grow growth plan for the Greater Golden Horseshoe. And they're designated settlements according to the County of Simcoe official plan. The lands are also designated village according to the township's official plan, designated village residential according to the township's secondary plan for Lagoon City. And they are zoned village residential according to the Township of Ramara zoning bylaw 2005-85 as amended. In accordance with staff report BP 1624 attached to today's agenda, the proposal complies or otherwise does not conflict with the provincial policy statement 2020, the Lake Simcoe Protection Plan, a place to grow, growth plan for the Greater Golden Horseshoe, and the County of Simcoe official plan. And then it is staff's opinion that the proposal does not offend the intent of the Township of Ramara official plan or the township zoning bylaw. So in terms of summary of the report and just comments received, I note concerns or disputes regarding valid or perceived access right to specific land coordinates under private ownership is a civil matter. So the planning department and the bylaw enforcement staff continue to educate that the municipality does not have jurisdiction to legally verify any access over these private lands. The subject lands shall continue under the existing ownership, whether the proposed boundary adjustment is finalized or if the existing lot fabric were to remain. The proposal does not conflict with the Planning Act or any relevant local or provincial land use planning policy. and does not result in any deficit to a required setback yard within the Ramara zoning bylaw, or it does not change the existing lot frontage of any of the properties. The proposal results in a realignment of the lot boundaries, which creates more efficient and desirable land use pattern between the 2724 Lone Birch and the 2728 Lone Birch Trail. Should the committee find it appropriate to approve this consent application, the following conditions are recommended. One would be satisfying the requirements of the Township of Ramara, financial and otherwise, including the payment of outstanding taxes. And secondly, the provision of a registrable legal description on the parcel in the form of a draft transfer prepared by a solicitor, together with a digital copy of the applicable reference plan. The suggested motion is that the Committee of Adjustment receive report BP 1624 dated May 14, 2024, and that consent application B124 be approved with the recommended conditions. And the alternative would be that the committee could deny or defer the application. Thank you.
Thank you, Krista. Mr. Lupo, would you like to come forward and make any comments at this time? No comments? Is there anyone in the audience or on Zoom that would like to make comments at this time? Seeing none, I guess we will, oh, go ahead. Sir, you give your name, please.
My name is Cameron Pierce.
Okay, thank you.
Good morning. I'm attending the meeting this morning to oppose the application B124. Block C was recently sold to the Lupos on October 23rd, 2023 by the Ministry of Infrastructure. Prior to that sale, the owner of Block C was Bertram Realty, which was vested to them in 1944. From 1944 up to the sale of the property to the Lupos in 2023, a total of 79 years, this property was used for access to the lake by residents without waterfront. My great aunt Amy, the previous owner of 2713 Lone Birch Trail, which is my current property interest, used Block C to access the lake. My grandfather, grandmother, father, brother, and sister, as well as other relatives, have used Block C to access the lake. My family has used Block C to access the lake for well over 50 years. I have fond memories of watching sunsets as a young child with my late father on Block C, playing with my friends who live at 2723 Lone Birch Trail, Matthew, Josh, and Luke Kappas, as a child, and more recently proposing to my now wife during a sunset at Block C. My children took their first swim in Lake Simcoe at Block C. I'm hoping my children can enjoy Block C and create lasting memories as I have. Myself and other residents are currently in the process of protecting our rights to access Block C through a prescriptive easement or an easement of enjoyment. It is my belief that the conveyance of a portion of Block C to 2728 Lone Birch Trail and the merger of Block C with 2724 Lone Birch Trail would impede our legal rights in obtaining this easement. Additionally, it is my understanding that once the portion of Block C is conveyed to 2728 Lone Birch and the remainder merged with 2724 Lone Birch, that the existence of Block C would be dissolved. I am also in opposition to application B124, as I currently have reached out to the Ministry of Infrastructure, the Minister of Infrastructure, and the Premier of Ontario regarding the sale of Block C. I'm currently seeking more information as to why it was sold when we have documentation from the previous owner that it was never to be sold, why it was sold without any announcement or information provided to those that would be affected by the sale, and why it was sold under market value for exactly half the assessed value. It is my intention to lobby the Ontario government to expropriate the land back to public use, and it is my understanding that application B124 would make this improbable. That is all.
Thank you, sir. Anyone else that make any comments on this application? I'm seeing none.
Yes, I have. This is Ali Ruslan.
Okay, go ahead, sir.
I'm the landowner on 2719 Lone Birch Trail. I share the same concern with Cameron and Darren as well on the line here. Got nothing else to add.
Okay, thank you, sir. Go ahead, sir. Your name, please.
Step up here to the mic, sir.
Yeah, would you, if you wouldn't mind stepping to the mic, because we are recording everything. Just push the center button.
I absolutely agree with Cameron's concerns and hope that this stops the progressive. What is it, C-24, whatever it is. Yeah, I agree with everything Cameron had to say.
Thank you. Anybody else, any further comments?
Yes, this is Carissa Clark. Can you hear me okay?
Okay, go ahead.
My name is Carissa Clark. Good morning. I am the sister to Cameron Pierce, and I have invested in 2713 Lone Birch Trail as well. I would just like to reiterate my brother's points on the opposition to the application of B124. Thank you.
Thank you. Further comments from anyone?
Yes, Darren DeShow, 2717 Lone Birch Trail. I purchased the property I reside at. In 2015, I was sold the property listed as deeded access. That turned out to not be the case, but I do have some documentation that we're bringing forward to support Cameron's claims as well. Thank you.
Okay, thank you. Any further comments? I'm trying to look on Zoom and in the audience at the same time. Okay, hearing comments. I think we'll just get the committee's opinion right now and we'll go from there. Their thoughts on this. Dan, what's your thoughts on this?
Well, this is new information that's just coming up. Right now, we got to follow what the township is recommending, and I went out and did a site visit. The sign was up, advertised. Right now, I have no concerns.
Okay, thank you. Tom?
Okay, I understand all the other owners' concerns, and I mean, if they've been using the property for 79 years and they're in the process of trying to get things changed. I'm not sure. I guess it was purchased in October by Mr. Lupo, and I don't know whether it should be deferred until these other people get their opinions and they're from wherever their lawyers or whatever is.
I just want to comment.
Go ahead, Jason.
Any kind of, I'm unaware, there may already be, as mentioned, legal proceedings happening. I'm not sure how deep in the pursuit they are or the timeline, whether that, legal case would take, would be this year or not.
Yeah.
That being said, as the current owners own 2724 Lone Birch Trail, and they now own the adjacent Block C, technically the lots would merge regardless of the boundary adjustment due to the identical ownership. So just wanted to note that the fact of the ownership of the two parcels in identical ownership does create a merger. So I did want to flag that, the boundary adjustment, regardless of any kind of access perceived or valid, the access to those land coordinates, would have to be ruled out by a court. It's not something that we would be able to have jurisdiction over or comment on, but just kind of wanted to highlight the application is not development. It's not creating additional lots, and it's a separate issue from the access, but I do definitely understand, the comments received, but it's just not something that we would have jurisdiction over. So I just wanted to kind of flag that and note that the lots are an identical ownership as is.
Go ahead.
Sorry, so neither of these lots are whole lots on a registered plan of subdivision. So block C and the Lupos property have merged. No, it is not. It is on a registered compiles plan, which is not a registered plan of subdivision. So the lots would have merged together. Yeah, so that they are definitely merged together as one piece. They could go to the land registry office right now and consolidate the pins into one piece.
And ma'am, please give your name too for the record. Yes.
Lori Bax. Registers compiled plans are sort of a gray area now. They used to be, as you say, they did not merge when you were a whole of the lots on a registered compiled plan. That's sort of going by the wayside. But theoretically, if the severance is granted, then by all means, then they would definitely merge into one parcel for sure. Nobody is concerned about the Lupos owning the property. The only concern is the people that are entitled to their access want their access to the lake. I have no idea why it was done in such a strange way and not just a straight lane to the lake. But that's what they want. That's all anybody wants, is to be guaranteed to have the rights that they paid for and that they have used for since 1944. The people that had the, and unfortunately, I don't think it's fair that everybody should have to go out and pay legal fees to enforce what is rightfully theirs.
Okay, thank you.
So if I just may, if this was an easement or a deeded access that's registered on deeds, the boundary adjustment would have no impact on the legal rights of the property. The easements just carry across through the legal description and they stay in the instrument number and they just kind of carry on and on and on. I understand that that's not the case for this perceived access. But if that's the case, if the access ends up being legalized, it would go on the property and carry across with it regardless of the boundary adjustment. And because the easement is not actually in the legal description, it is a separate item, right? So I do understand the concerns here, but from the committee's perspective and the township's perspective, they are separate items. So by deferring or delaying the approval of this, it does put the municipality at risk of appeal to the Ontario Land Tribunal because it is a separate matter that is separate from the actual conveyance. We have lots of changes in lot boundaries where there's easements across and the easement just carries on through the legal description. So it is done at the Land Registry Office through the courts. It is separate from this Planning Act application.
Could you elaborate on the risk from the land tribunal?
So if the committee defers the application, the applicant can appeal the deferral to the Ontario Land Tribunal. And then the municipality will need to go to the Ontario Land Tribunal to defend the reason for the deferral. So if it's not a reasonable reason, I hate to say reason twice, but if it's not a land use planning matter, then the Ontario Land Tribunal would make the decision at that point, and the municipality would have to pay for that.
Just to reiterate one of my concerns, I believe that the merger of the lots would make it obtaining the registered easement more difficult as opposed to just the Block C as it currently exists. I mean, that's my main reason for opposition. And I'm assuming, and again, it's an assumption, that once the lots are merged, it would be more difficult to obtain that easement.
That would be beyond my purview, really, to say if that concern is valid. I don't know where that concern is coming from, like where your concern is coming from. But if it would still be identified. Like, so when the lot is conveyed, when that section of Block C is conveyed, it will be part of Block C. Part 2, registered plan, 51R, yada, yada, yada. So that the legal description of the property will still contain part of Block C. So if there is ends up being a prescriptive right of way across Block C, then the courts or the powers that be would rectify it at that point.
So my question is are there boundaries being redrawn? Are the maps going to change?
So that the maps have already changed because Block C and the Lupos property would have merged together. So the parcel fabric gets merged and then it gets updated through Terranet from the Land Registry Office. Then MPAC consolidates the pins, consolidates the pins and the roll numbers. And then they send that updated information to the municipality. So the individual roll number for Block C will eventually cease to exist. It could cease to exist right now. But the actual land itself and the description of it does not change. So it would be part of Block C plus lot, yada, whatever the Lupos property is for legal description. Sorry, it's not in front of my face, but it would be 2724 Lone Birch Trail plus part of Block C as identified on a separate part of a register of a reference plan. So the roll numbers can change, like MPAC will even change people's roll numbers sometimes. And there's other times where the Land Registry Office will, consolidate 2 properties and put them together with one pin. If it's not a whole lot on a registered plan of subdivision or a property that's created by consent, then they will merge together on title. Sorry, I don't know if that answers your question. I went a little rambly.
I do have one other item just to add, just to clarify. The Committee of Adjustment has the authority to make decisions on matters regarding minor variance consent applications, etc. But the Committee of Adjustment does not have the power to deny or grant illegal access. It's just not something that is in their jurisdiction or the townships. So it's not something that we can require that suddenly these landowners on record, private landowners, that through this application, we restrict and require they open their lands to the public when they are privately owned. The committee does not have that power. The township does not have that power. It is something that is a civil matter, not in a separate from the application. So I just wanted to make that very clear. Why staff is advising it is separate. We don't have the power to grant access in this manner. Because and that's an application is not being applied for access. It's not an easement application. It's a request for an adjustment to the boundary between 2724, which has merged with Block C, as well as 2728, just to clean up the lot boundary between the 2 neighboring lots. So I hope that kind of helps clarify the scope of the application.
Yeah, we understand that this is not an application for an easement, but it is our concern that the passing of this application would make it more difficult to obtain an easement. And until we have, until we have a decision whether or not we will be granted an easement or not, I believe that this should be deferred until then.
I just want to further clarify that the committee would not be granting an easement to this property. It would be just the court who could, clarify any legal access.
Go ahead, Tom.
Okay, having heard all that and everything, I guess give consent for the application, like approve the application, and I guess the property owners, have to look into legal ways or whatever ways they have to get their right of way back. That's, if the property's already merged now, we'll just approve the application and then the people can go about their complaints or whatever with the Crown or whoever the Ontario, whoever. But if the township or we can't do anything, I guess that's the way they're gonna have to go. So I have no problem with the application then.
Thank you, Tom. Well, we as a committee here on this application here, we can understand your thoughts. We're kind of stuck between a rock and a hard place on this. Legally, the Lupos have got legal representation. It shows that there's never been any legal access granted on the deed of Block C. However, if they were I'm going to word this. I guess what the question I should ask, the property owners that own across the road from on the back lots, when you bought properties, a lot of people have been saying that they were told that they were granted access. Was there ever anything on your deeds that said any legal access was granted at that point?
Definitely, yeah. That was on our documents indicating that we have deeded access to the properties, to the Block C.
Okay.
Block C is actually subject to an easement.
Yeah.
If you look at if you look at the pin page for Block C, it does set out that it is subject to an easement for the rights of the various landowners. Some people, their deeds, the ones that have lived there for a long time, their deeds do say together with Block C. When the electronic system came in, and I don't know if this is, it's probably above, but land titles and land registry, the government decided to convert everything into an electronic TerraView system. When they did that, they only went back 40 years from the time that they were doing it. So some people did lose their rights of way. Not in this particular area, because Block C specifically is subject to an easement, and it has been brought forward again by another previous owner, if you were to look at the pin page. So most of the people do have the right to use Block C.
Thank you. Well, I guess I'm still, as the way Tom feels, our hands are tied on this. Basically, if you want to go further on this, it's a civil matter and we can't do anything about it. I mean, we're pretty well bound as a committee because everything on the application is all, is up front and everything. So I think that we just have to stand with the way the application is presented and approve the conveyance of the land. And I'm sorry to say that I know you don't want to have to get into legal costs, but it may be the only way that you can go to the provincial authority that allowed the land to be sold and take your questions to them. Anyway, yes, go ahead, sir.
Sorry, I don't see why this matter can't be deferred for a later date so that we can get our ducks in order and come back and address this, because this is all happening way too fast. It's being pushed through, and I feel like we're being bullied as a community, and I'm really not impressed, guys.
Okay, now, according to what I believe it was Jennifer said, if we defer it, then it's going to go to the appeal tribunal. Is that not the case, Jennifer?
So the applicant would need to, I see you, Nick. I will get to you and we'll get to you in 1 sec. The applicant would need to appeal to the Ontario Land Tribunal.
Okay.
But just in a different scenario, the way that you can tell that these two things are separate is because if there's a prescriptive right of way or a legal right of way across this block, and somebody wants to cut it in half, that legal right of way is going to maintain across the property. I think the concern really is that everyone is worried about how it's fenced. Who owns that property does not necessarily change who has a legal access across the property. So just keeping that in mind, by not allowing this to happen isn't going to help the situation. The legal access is the legal access, whether it's there or not. So it is just separate from the boundary adjustment. And while we can understand that there is a civil happening here that needs to be dealt with, it's not in the township's hands, and it really doesn't impact the application. But Chair, Nicholas, sorry, I can, Kotsopoulos, sorry, is the solicitor for the Lupos, and he's online and just wanted to speak.
Okay, go ahead, sir. Would you like to speak?
Yes, yes, sir. Okay, it's Nicholas Kotsopoulos, counsel on behalf of the Lupos. I've heard the concerns of the neighbors. I would reiterate and concur with the panel that it's not the town's mandate to speak to legal or prescriptive rights. That being said, in terms of access on Plan 874, there are town-owned pathways and rights and access points to Simcoe. So the application before the town this morning, and whether it's approved or not, would have no bearing on the ability of other owners on Plan 874 to access Simcoe via the other points or the other blocks on Plan 874, our registered Plan 874. That being said, specifically Block C, there's no specific reference to rights of way to individual parcels or other lots on RCP 874. So there is no specificity there. And in terms of the other owners who suggest they may have had deeded rights, we see that language quite often in the real estate transactional world. Deeded rights, though, often that phrasing or that parsing may be used by realtors almost in an advertising capacity. But again, deeded rights would speak to rights that are specifically enshrined or spoken to on title via instruments that are registered on title. And Block C doesn't speak to any specific parcels on 874 that have a right over it in terms of specificity. And in terms of prescriptive rights, there is a common law test there. I think we don't need to get into it here, as we've confirmed that the mandate of the town is not to evaluate or adjudicate prescriptive rights, but there is a common law test that does speak to the ability, in part at least, those who are seeking to prove that part of that test is that those owners are able to indicate, in addition to other prescribed criteria, they're able to indicate that, in this case, access to the water, Block C is necessary, is a necessary component to their ability to access the water, and that's not the case when it comes to Plan 874, or RCP 874, particularly because Blocks A and Block D, and additionally, it appears Block E also provide access to the water.
Thank you, sir. Okay, I guess we pretty well heard as much as we can on this application. I think our committee is pretty much in favor. Could I have a mover and a seconder to move by Dan, second by Tom, to approve the conveyance of the land? All those in favor? That's carried, so noted. I guess we'll move on to our next application, and I believe that is what? 2510 Lakeshore? Do we have people representing 2510 Lakeshore? Would you like to come and just give your name first, and then the Secretary Treasurer will read the report, and you can sit down until you wish to make further comments.
Rose Antonio.
Okay.
That's it.
Okay, if you want, the Secretary Treasurer will read the report, and you can make further comments afterwards.
Okay, for item 4.3, we're discussing file A324 at 2510 Lakeshore Drive. An application has been submitted by John and Rose Antonio, owners requesting permission for a reduction in the minimum high water mark setback to allow for an approximately 40.5 square meter addition to the existing dwelling and a 14 square meter unenclosed roof above the existing deck. And the proposal will require the following variances to the township zoning bylaw. So it would be section 2 and 2.8, which is the minimum high water mark setback. So the proposed setback for the unenclosed deck cover is 12.20 meters, and the proposed setback to the addition is 14.7 meters. So a variance is requested for 2.8 meters for the deck cover and a 0.3 meter variance request to the high water mark for the proposed addition. And here is the existing cottage. And so the extension of the cottage is proposed to be out this way. And then in terms of the decking, there would be a cover here. So, and the setback is demonstrated. I'm just going to go to the next slide. In terms of circulation, we were circulated in accordance with the Planning Act. And both Building and Infrastructure Department reviewed the applications and had no concern, or sorry, the application, singular. And then Lake Simcoe Region Conservation Authority requires a planting plan for the shoreline area just to compensate for development occurring within the 15 meters of the Lake Simcoe. And they also just require that the applicant obtain a permit through the LSRCA since it's within their regulatory boundaries, and to pay the variance application review charge. Otherwise, no further comments have been received to date. The subject property is within the boundary of the Lake Simcoe Protection Plan, is regulated by the Lake Simcoe Region Conservation Authority and under the rural designation of the County of Simcoe Fish Plan. And it is also designated shoreline residential according to the township's official plan and is zoned shoreline residential according to the township zoning bylaw. In accordance with staff report BP 1224, the proposal complies or otherwise does not conflict with the provincial policy statement 2020, the Lake Simcoe Protection Plan, the County of Simcoe official plan, and staff are of the opinion that this proposal does not offend the intent of the township's official plan or Township of Ramara zoning bylaw. Just to kind of summarize the report, the subject parcel is an existing lot of record for residential use. The existing dwelling was constructed in 1948 and is considered to have legal non-conforming status. And the proposed addition will not encroach the high water mark any further than the existing dwelling. The proposed deck roof cover is an extension to the existing dwelling's roof, does not encroach the high water mark setback any further than the existing deck. We do note with the current building permit that was issued for the foundation that the deck has been removed for that repair. So if you did a site visit, it is not there currently. Section 34.9 of the Planning Act permits legal non-conforming uses in building, provided that the lands and uses are continued. And that the proposal otherwise complies with Ramara zoning bylaw. It's staff's opinion that allowing the expansion of this building does not impede the proper development of the residential parcel and does not have adverse impacts to the surrounding community. So should the committee find it appropriate to approve this application for permission, the following conditions are recommended. And one is that the roof above the existing deck remains unenclosed to just avoid any further development to the lake or toward the lake. And that a planting plan for the shoreline area be provided to the Lake Simcoe Region Conservation Authority as requested, as to compensate for the development occurring within 15 meters of the high water mark. In consideration of an application for the enlargement or extension of what has been determined to be a legal non-conforming use or building under section 45(2)(a)(1) of the Planning Act, the Committee of Adjustment must be satisfied the following. One is whether the proposal is appropriate and desirable for the appropriate and orderly development of the land, and whether the proposal triggers any adverse impact to the surrounding lands and neighborhood. The suggested motion for this application is that the Committee of Adjustment receives report BP 12, published the May 14, 2024 meeting agenda, and that permission application file A324 be approved with the recommended conditions. Alternatives are that the committee could deny or defer the application.
Thank you. Would you have anything further to add to the comments? Go ahead, sir, if you'd come up to the mic, please. Yeah, just.
Good morning.
Center if it's not.
Good morning.
Okay, very good, sir.
Husband, John Antonio, same address, 2025-10 Mitchell. Just one comment, Jennifer?
Carissa.
The drawing that you showed of the actual cottage, could you put it back up there 1 second, please? As you see, the roof that is overhanging on there, our structural engineer is going to just make it a little bit shorter, but the side entrance where you see the deck right there,
Yes.
it's going to have an overhang because that's going to be our major, just so we're out of the rain, because that's our major entrance to the cottage when we do arrive. We always been using that side entrance, so it doesn't have an overhang to get out of the rain. That's about it.
Okay. Thank you, sir.
Just want to clarify the overhang. Is that on that the addition is going
No, on
this?
Oh, yeah, yeah, you see where the porch is on the side?
Yep.
There's no overhang to
But
get out of the rain, so there'd be a little overhang.
Right. Actually,
That
in
door.
yeah, I'm looking at it. It's already 10 feet from the
Yeah, it is.
yep. So
10
in the height of that floor is less than 2 meters.
Right.
Perfect. So that then your projections apply. So it could be, yeah, I just was looking at that and
Got to just.
I wasn't,
Thank you.
sorry about that. I just wasn't sure if that was something that we'd already discussed, but I do recall that now and it does meet the setback. So perfect.
Okay, then.
Thank you.
Thank you. Is there anyone else on Zoom or in the audience that can make comments on this application? Okay, thank you, then Jacob. I guess we'll go around the committee. Tom, you're.
No, I was at a look and I have no problem. Yeah. I was out and had a look and I have no problems with the application.
Dan.
I also did the site visit. The sign was out and I have no concerns.
Yes, I as well. I did a site visit. You're doing a lot of work to restore the building. It's going to look good when it's finished. And I have no problem with the application as presented. With the variances are extremely minor. So I guess we seem to be all in agreement on this. Mover and a seconder, please. Moved by Dan, second by Tom, that this application be approved. All those in favor? And the application is carried. Thank you very much for joining us. Okay. The next application, Carissa?
Yes. Agenda item 4.5, file A424 at the property 4345 Orkney Beach Road. So we just have a site plan here, as well as the aerial just showing where the
Carissa, sorry
property
to interrupt.
is.
Do we have someone to represent that? You would like to come forward? Just give your name, sir, for the record.
Morning.
Good morning.
Mark Taylor, 4345 Orkney Beach Road.
Okay, thank you very much. She'll read the report. You can make any comments afterwards.
Thank you. And then we have the existing boathouse, and then the highlighted area is where the proposed pavilion cover would be. And I guess I should actually explain what the application is. So it has been submitted by Mark Stephen Taylor, owner, requesting a minor variance for an increase in the maximum height permitted for a boathouse. And this is in order to allow for an approximately 26 square meter unenclosed pavilion addition to the decked roof of the existing boathouse. So section 212D is requested to be varied as the zoning bylaw requires a 4.5 meter elevation from the high water mark. The proposed is 7.6 meters, so the variance requested is 3.1 meters. Additionally, the applicant has provided a cross section just showing, hey, this is the existing boathouse and the decking And then this is the proposed pavilion atop, and then here's just a picture of the existing boathouse. We did circulate the application in accordance with the Planning Act, and internal departments had no concerns. Lake Simcoe Region Conservation Authority, they did note no concerns, and they just require that the applicant obtain the permit as the property is regulated by the LSRCA, and that they pay the LSRCA variance review charge. Now, we did receive comments yesterday after hours. Sally and Roy, adjacent landowners, outlined concerns regarding waterfront view and the proximity of the proposed construction. Now, as the comments were not published due to them coming in a bit later, I do need to read them now. So bear with me. I just got to share my screen for those comments. There it is. Thanks for your patience. So the comments read as follow. Our neighbor 4345 Orkney Beach Road applied to build a pavilion on their deck. I do have some concerns. One, the pavilion is a bit too close. As below pictures show, our house is very close to the deck, 2.45 meters apart apart in between, and 3.9 meters in front of our home. The pavilion is also a bit too high. Our house is 1 story and built on a slope. The sunroom is on top of the basement, partial walkout. The sunroom is only 2.43 meters above the ground. The pavilion will be 3.8 meters high from the ground, measured from ground level to the top of the pavilion. The pavilion is a bit too big. The length of the pavilion is 6.1 meters. It is a 26 square meter pavilion. Our concern is this structure will block a lot of our view. We kindly request for our neighbor if they can make the pavilion lower, maybe 8 feet, and smaller to limit the amount of lake view that we'll lose once it's built. We hope that you can bring our concern to the committee. Thank you for your assistance. And then just wanted to show those pictures of their property as shared with the comments. So we have the subject property, and I believe the mentioned property. Again, boathouse here, subject property, and I think the enclosed sunroom they were discussing is here. And then the boathouse is over here. And I believe, yeah, and they also just highlighted their property on the sketch provided with the application. So I'm going to switch back to the PowerPoint. Okay. In terms of policy, the subject lands are within the boundaries of the Lake Simcoe Protection Plan under the regulatory boundaries of the LSRCA and are designated green lands according to the County of Simcoe official plan. They are also designated shoreline residential according to the township's official plan. They abut the Atherley up to Grove settlement boundary and are designated village residential within the secondary plan for the Atherley up to Grove area, and further are zoned shoreline residential in accordance with the township zoning bylaw. In accordance with staff report BP 1324, this proposal complies or otherwise does not conflict with the provincial policy statement 2020, the Lake Simcoe Protection Plan, and the County of Simcoe official plan. Staff are of the opinion that this proposal does not offend the intent of the township's official plan or the Township of Ramara zoning bylaw. And just to summarize the report, the existing boathouse was constructed in the 1950s and location in use is permitted under the current zoning bylaw. Height of the proposed roof is approximately 3 meters if measurement is taken from a level grade. However, at this location, the average elevation from the high water mark to the mid peak of the proposed roof cover is about 7.6 meters. Height requirements compliance is a bit more challenging at this location, and that's due to the steep grade decline that starts in the roof of the existing boathouse, as there's less room to work with compared to lands with more level shore areas. The proposal does not encroach the interior side yard and all other provisions of the township zoning bylaw. and it maintains an appropriate distance from the neighboring lots. The requested encroachment to the maximum building height can be considered minor, provided that the proposed pavilion remains unenclosed, just to maintain a desirable shoreline character. Should the committee find it appropriate to approve this minor variance application, the following condition is recommended to be added to the approval, and it is that the subject pavilion proposed to be attached to the deck roof of the existing boathouse shall remain unenclosed. Should the committee find it appropriate to approve this minor variance application, the following reasons can be provided. The general intent and purpose of the zoning bylaw will be maintained. The general intent and purpose of the official plan will be maintained. The requested variance is desirable and appropriate for the development of the subject lands, and the requested variance is minor in nature. Should the suggested motion is that the Committee of Adjustment receive report BP 1324 published on the May 14, 2024 meeting agenda, and that minor variance application A424 be approved with the recommended condition. And the alternative would be that the committee could deny or defer the application.
Thank you, Krista. Mr. Taylor, would you like to make any more comments? You're good? Okay. Anyone else making any comments? I don't think we have anyone on Zoom or in the audience. Tom, your feeling on this?
I have no problem with the application as it's, but I can understand the people not wanting their view obstructed. And if the people could just kind of work together a little bit to maybe try to, make that come a little better for the other people, then that would be good. So I have no problems.
Dan, your comments?
I could also understand the neighbors, but again, we got to follow the recommendations from the township, and everything else was there. The sign, I have no concerns.
Thank you, Dan. Yes, I visited the property on Sunday, and first off, it's down to this same old story. No one has a right to a view. It is as Tom mentioned, if you work with your neighbors, it's great. I have no problem with the application as such. I would have had a problem if it would have been an enclosed structure, because then it would have looked like it could have been habitable space. Any case, the big issue here is the slope of the ground, and we're using the high water mark as a focal point for starting your elevation. And so really, it seems like a lot, 7.6, but if you look at where the water is, the boathouse and the water down from it may not be as high as what you think it's going to be in reality once you're finished. So again, I have no problem with the application. Seems like we're in agreement. Mover and seconder, moved by Tom, second by Dan. All those in favor? That motion is carried. Mr. Taylor, good luck with your project. Thank you. Thank you. And I guess we'll continue on, Carissa. This will be Amelia Drive next. Your name, sir, good for the record.
Bruce Ralph, 3612 Amelia Drive.
Okay, thank you very much.
Perfect. So we'll discuss 3612 Amelia Drive with the owner present, Bruce Ralph, under agenda item 4.7 for file A524. An application has been submitted by Bruce Ralph, owner, requesting a minor variance for reduction in the minimum interior side yard setback and an increase in the maximum lot coverage to allow for the construction of a new single-family dwelling with an attached garage and deck. And the proposal will require the following variances to the township zoning bylaw, which would include a minimum interior side yard setback to the east lot line, as well as the minimum interior side yard setback to the west lot line. Either way, it's 1.5 meters. The east side proposed is 1.23 meters, and the west side is 1.22 meters. So we have a slight variance for either interior side yard requested, and then a 2.4% increase in the maximum lot coverage permitted in the SR zone. We do have a site plan here of the proposed, and it just shows the attached garage, dwelling. And then also there would be a proposed, future deck as well. And then does show these setbacks here. Again, the application was circulated in accordance with the Planning Act. The building department reviews the proposed septic design submitted with the application as to confirm the area of land being left for septic is large enough. And after that review, they confirm no concerns. Infrastructure department commented that they have no concerns as long as applicant can demonstrate that a swale will be incorporated within the 1.22 meter and the 1.23 meter side yard area. They also note no pipes are to discharge within 5 meters of any lot lines, no utilities to be installed in the side yard, such as propane tanks, air conditioners, or others, and that could impede the drainage or the maintenance thereof. Any changes to the entrance triggers an entrance permit by the infrastructure department. So those items can be captured in the zoning and grading review, which would be the next step. The Lake Simcoe Region Conservation Authority requires that the applicants obtain a permit through the LSRCA and pay their variance review charge, but otherwise had no concerns with the application. And no further comments have been received to date. In terms of policy, the subject lands are within the boundaries of the Lake Simcoe Protection Plan under the regulatory boundary of the LSRCA and designated rural and green lands according to the County of Simcoe official plan. The subject lands are designated shoreline residential according to the township's official plan and are zoned shoreline residential according to the Township of Ramara zoning bylaw. In accordance with staff report BP 1424, this proposal complies or otherwise does not conflict with the provincial policy statement 2020, the Lake Simcoe Protection Plan, and the County of Simcoe official plan. Staff are of the opinion that this proposal does not offend the intent of the township's official plan or township zoning bylaw. To summarize the staff report, lot frontage of the subject property is approximately 15 meters, which does not meet the minimum frontage required currently for lot creation in the SR zone. However, redevelopment can be considered appropriate as the subject property is an existing lot of record created for residential purposes. The existing legal non-conforming shed on the property currently encroaches the front yard setback. At the demolition stage of the project, it will be removed. So the property will be brought into conformity with the front yard setback provision, and the proposal complies with the high water mark setback to Lake Simcoe. According to MPAC report on file, the subject lot is about 0.13 acres. A maximum 30% lot coverage is permitted within the SR zone. So the owner is proposing to have approximately 1,230 square foot house with an attached about 180 square foot garage and a 40 square foot deck. Due to the size of the existing lot, the request for a 2.4% increase in lot coverage can be considered minor in order to fit a moderate sized dwelling on the property. Given the narrow width of the lot, the required interior side yard setback is a bit more difficult to meet. As such, a slight encroachment to the east and west interior side yards by less than 1 foot per side can be considered minor and can be supported to accommodate a modest sized dwelling. Should the committee find it appropriate to approve this minor variance application, the following condition is recommended to be added to the approval. That is that the variance pertains only to the request as submitted with the application. And this is just so that, you know, if they wanted to put other structures in the future that they wouldn't have a 1.22 setback, it would have to meet the 1.5, and then any additional lot coverage would need a variance. Should the committee find it appropriate to approve this minor variance application, the following reasons can be provided. The general intent and purpose of the zoning bylaw will be maintained. The general intent and purpose of the official plan will be maintained. The requested variance is desirable for the appropriate development of the subject lands, and the requested variance is minor in nature. Suggested motion is that the Committee of Adjustment receive report EP 1424, published the May 14, 2024 meeting agenda, and that minor variance application A524 be approved with the recommended condition. Alternatives are that the committee could deny or defer the application.
Thank you, Krista. Mr. Ralph, would you like to make any comments? You're good? Okay. Tom, you're
No, I have no problems with the application. Seems good.
Dan?
I also have no concerns. I did a site visit and the dwelling needs to be replaced soon.
Yeah, I did a site visit on Sunday and your garage door was open, so I had to peek behind to make sure the sign was there, but it was there. I kind of figured that's where it would be. Any case, you got a tight lot to work on. That's about, and we run into this all the time on some of the narrow lots. And you're trying to capitalize on this space that you have. And you're basically, normally we like to see 1.5 meters from side yards, but in your case, as long as you can work a swale in and no other fixtures are on the side yard, I can't see any problem with it. And another thing I liked was you've had it surveyed. I can see the survey stakes, so these dimensions are going to be accurate. Let's put it that way. So that settles my fears at all that way. So I have no problem with it. It seems like we're all in agreement. Moved by Dan, second by Tom, that this application be approved. All those in favor? This application is approved and carried. Thank you, sir, for joining us. Okay, I guess, Marissa, you're gonna read, there's some comments you're gonna read and go from that.
I think we just, I think for the comments, we've got those covered, but we should probably move to adoption of minutes, if the committee had any
Okay.
additional revisions to that.
Okay, the minutes of I guess the last meeting was February, wasn't it? Everyone's read the February minutes, and is there any additions, deletions, whatever need to be made? If not, could I have a mover and a second for the February minutes? Moved by Tom, second by. We've missed 2 meetings, haven't we?
We haven't had a March or an April meeting.
Yeah.
But we did have a January and a February.
So it would be February, Dan. So we missed 2 meetings basically. So the last minutes published were February minutes, so. Are you good to second that then? Oh, that's, yeah. Then that means that I guess I'll have to second it. It's not just the chairman shouldn't be doing that. So that motion is carried. So all those in favor? Good, it's carried. Now the next thing was about a chairman for the following year, which really should have been done in January, but it got kind of missed.
Yeah, so when reviewing the procedural bylaw, we definitely need to appoint a new chair for the remainder of the 2024 calendar year. So at this point, a committee member could come forth and volunteer, or otherwise the committee could cast a vote with either present or if unpresent member. It's really the committee's decision.
Chloe has agreed, but are you both agreeable with Chloe being, okay, Chloe has agreed to do it. In the event that she has to miss meetings, I've told her that I would fill in if that's acceptable to the, but do we actually need a motion as such?
Yes, so I have a motion ready, but I didn't have a name, but
Okay.
I can read out a motion, and then if the committee wants to approve, they can. So the recommended motion would be that member Chloe Black be appointed chair to the Committee of Adjustment for the duration of the 2024 calendar year.
Okay, and I guess we would need someone to second that motion. Be seconded by Tom. All those in favor? That would be carried.
Perfect. Okay, so that item 6.1 is taken care of, and then just wanted to note the proposed draft procedure bylaw under 6.2. And essentially, we just wanted to update the bylaw a bit and just combine the existing refund policy just so that it was kind of attached to something so that we could give it out to people, and they would have access to the full bylaw with all of the policies. And we also did establish some new policies within the procedure bylaws, such as recirculation, errors and inactive file protocols. That way, if there is an application, maybe the committee's deferred it, or perhaps the application just was never deemed complete, or there was issues at circulation. At least now, we do have opportunity to eventually close a file. So we did try to make that policy fair. And the proposed policies are highlighted. So I'm not sure if the committee has had a chance to review that, or if they have any
I
objections.
went over most of them, particularly the highlighted areas, because I knew that would be the something that was different. I guess my question is, has the council actually adopted that yet? Or will that be before their next meeting?
Basically, it's up to if the committee does not have concerns as presented,
Okay.
it would then go to committee of the whole for council to discuss. And then
Okay.
from there, if they would like to adopt at the next council meeting, they could do so.
So do we need to make a motion on that or not?
Yes, I do have a recommended
Okay,
motion
go
here.
ahead then.
That the Committee of Adjustment approves the proposed 2024 draft procedure bylaw as presented, and that the Committee of Adjustment proposed 2024 draft procedure bylaw is forwarded to the next Committee of the whole meeting for council's consideration,
So we need a mover and a seconder from the committee then?
if in agreement with the
Okay, yeah.
proposal.
Moved by Dan, second by Tom, that this be approved and it can go on to council. Okay, is there any new or unfinished business at this time?
I think that was about it.
Just,
Did you have something, Jennifer?
yeah, just
Go
to add, we will need to relate with clerks. We will have to advertise for a fifth member. As Joe Goff was successful in the by-election last night. So we will be working with clerks to fill that seat.
Okay. Thank you. So I guess we better have a motion to adjourn. Moved by Tom, second by Dan, that we adjourn at 10:41. Thank you everyone for coming this morning.